Hi friends, you got it right. I went to the beach with my headset on. So I'll be reading the continuation of the cases on taxation decided by the Supreme Court in 2018 and 2019. We're now on taxpayers' remedies. And if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. Recovery of tax erroneously or illegally collected. Commissioner of Internal Revenue versus Cebu Holding Incorporated. GR number 189792, June 20th, 2018. Facts. On April 15, 2003, Cebu Holdings Incorporated filed with the Bureau of Internal Revenue its income tax return for the year ending December 31st, 2002. Cebu Holdings indicated in its ITR that it was obtained to be issued a tax credit certificate for the alleged overpayment of $18,992,055. Later, on March 4, 2005, Cebu Holdings filed with the BIR a written claim for a tax credit certificate for the same amount. When the Commissioner of Internal Revenue failed to act upon Cebu Holdings' claim, the latter filed a petition for review with the Court of Tax Appeals, First Division, on April 15, 2005. The CDA granted the petition. However, it found various discrepancies concerning some of the creditable withholding taxes and disallowed such. The CDA and bank affirmed the decision of the division. Issue: was Cebu Holdings entitled to tax refund or tax credit? Ruling: yes. Cebu Holdings was entitled to tax refund or tax credit. The requisites for claiming a refund or excess creditable withholding taxes are: 1. The claim for refund was filed within the 2-year prescriptive period. 2. The fact of withholding was established by a copy of a statement duly issued by the payer withholding agent to the payee, showing the amount of tax withheld therefrom. And 3. The income upon which the taxes were withheld was included in the income tax return of the recipient as part of the gross income. All these requisites were followed by Cebu Holdings. It filed a claim for refund within the 2-year prescriptive period, submitted the certificate authorizing registration, withholding tax remittance returns, and certificates of creditable tax withheld at source, upon which the independent CPA based his report and submitted its amended 2002 ITR to show that the income upon which the taxes were withheld was included in its ITR. Thus, it is entitled to tax refund or tax credit. Local government taxation, tax ordinances. City of Pasig et al. Versus Manila Electric Company, GR 181710, March 7, 2018. Facts. The Sangguniang Bayan of the Municipality of Pasig enacted an ordinance which imposed a franchise tax on all business venture operations carried out through a franchise within the municipality. Later, said municipality was converted into City of Pasig. The City Treasurer's Office informed Manila Electric Company, or Meralco, that it was liable to pay franchise taxes. Meralco protested the validity of the demand, claiming that the same be withdrawn and cancelled for the following reasons. 1. The ordinance was declared void ab initio by the Department of Justice for being in contravention of law. And 2. The Regional Trial Court of Pasig City ordered the LGU of Pasig to refund Meralco because municipalities are not empowered by law to impose and collect franchise tax pursuant to Section 142 of the Local Government Code. Issue: is Meralco liable for franchise tax imposed by the LGU of Pasig? Ruling: no. Meralco is not liable for franchise tax imposed by the LGU of Pasig. Under the Local Government Code of 1991, a municipality is bereft of authority to levy and impose franchise tax on franchise holders within its territorial jurisdiction. That authority belongs to provinces and cities only. A franchise tax levied by a municipality is thus null and void. The nullity is not cured by the subsequent conversion of the municipality into a city. Here, as the subject ordinance was passed by Pasig, when it was still a municipality, it is bereft of the authority to levy and impose franchise tax. Meralco is not liable to pay said tax. Another case, City of Manila versus Cosmos Bottling Corporation, TR number 196681, June 27, 2018. Facts. The City of Manila assessed Cosmos Bottling Corporation, or Cosmos, local business taxes. Cosmos protested the assessment, arguing that Tax Ordinance number 7988 and 8011, amending the Revenue Code of Manila, RCM, has been declared null and void for failure to comply with the required publication for 3 consecutive days, and thus cannot be the basis for the collection of business taxes. The city treasurer denied the protest. Issue. Are Tax Ordinance number 7988 and 8011 valid basis for the imposition of business taxes? Ruling, no. Tax Ordinance numbers 7988 and 8011 are not valid basis for the imposition of business taxes. Consistent with settled jurisprudence, taxes assessed based on void ordinances must perforce be nullified. Tax Ordinance number 7988 and 8011, which amended Ordinance number 7794, are null and void for failure to comply with the required publication for 3 consecutive days. Thus, either cannot be the basis for the collection of business taxes. Taxpayers' remedies. International Container Terminal Services versus the City of Manila et al. TR 185622, October 17, 2018. Facts. International Container Terminal Services, or ICTSI, was assessed for local business taxes. It paid under protest. When the city treasurer failed to act on its protest within the prescribed 60-day period, it filed for a petition for certiorari before the regional trial court. The RTC dismissed the petition for failure to comply with the requirements under Section 195 of the Local Government Code. ICTSI counter-argued that their petition was in the nature of a claim for refund under Section 196 of the LGC. Meanwhile, ICTSI wrote a letter to the city treasurer claiming refund for the taxes paid from the 4th quarter of 1999 up to the 2nd quarter of 2003, and for the 3rd quarter of 2003 up to the 2nd quarter of 2005. These claims were denied. The CDA Division on Petition for Review ordered a partial refund representing the erroneously paid business taxes for the first 3 quarters of 1999. Pursuant to this decision, ICTSI sent its letter to the city treasurer claiming a refund of taxes paid for the 3rd quarter of 2005 until the 4th quarter of 2006. These claims were likewise denied. No separate written claims for refund were made for the taxes paid thereafter, as ICTS believed that there was not further necessity for it. Upon appeal, the CDA and Bank found that ICTSI raised the applicability of Section 196 for the first time on appeal. It denied ICTSI's petition for review and affirmed the CDA Division decision. Hence, this petition. Issue. Did ICTSI failure to file written claims of refund amount to non-compliance with the doctrine of exhaustion of administrative remedies? Ruling, no. To be entitled to a refund under Section 196 of the LGC, the taxpayer must first file a written claim for refund or credit with the local treasurer. Regarding this requirement, the records show that ICTSI made written claims for refund for the taxes paid from the 4th quarter of 1999 until the 4th quarter of 2006 through the letters to the city treasurer. As for the taxes paid thereafter, which were not covered by these letters, ICTSI no longer made separate claims because of its belief that any subsequent written claim would have likewise been denied or would similarly not be acted upon. The doctrine of exhaustion of administrative remedies requires recourse to the pertinent administrative agency before resorting to court action. Otherwise, the case shall be dismissed. If a party can prove that the resort to the administrative remedy would be an idle ceremony, such that it will be absurd and unjust for it to continue seeking relief that evidently will not be granted, then the doctrine will not apply. In this case, the filing of written claims with the city treasurer for every collection of tax would have been denied by the city treasurer every time. Thus, ICTSI's failure to file written claim for refund for all the taxes paid subsequent to the fourth quarter of 2006 is warranted, is an exception to the application of the doctrine of exhaustion of administrative remedies. Claim for refund of tax. City of Manila versus Cosmos Bottling Corporation, GR number 196681, June 27, 2018. Facts: the City of Manila, through its city treasurer, assessed Cosmos Bottling Corporation, Cosmos, local business taxes. Cosmos protested the assessment. The city treasurer denied the protest. Nevertheless, Cosmos paid the amount assessed and filed a claim for refund. Due to the inaction of the city treasurer of Manila in the claim for refund, Cosmos filed a complaint with the regional trial court. The RTC ruled in favor of Cosmos but denied the claim for refund. It then filed a petition for review before the CTA. The CTA ordered the refund of the amount paid. The City of Manila sought reconsideration, but their motion was denied, so they appealed before the Supreme Court. The City of Manila submits that the assessment against Cosmos became final and executory when the latter effectively abandoned its protest and instead sued in court for the refund of the assessed taxes and charges. Issue: may a taxpayer who filed a protest and paid the disputed assessment later on institute an action for refund? Ruling: yes. A taxpayer who had protested and paid an assessment may later on institute an action for refund. There are two conditions that must be satisfied in order to successfully prosecute an action for refund in case the taxpayer had received an assessment. 1. Pay the tax and administratively assail within 60 days the assessment before the local treasurer, whether in a letter protest or in a claim for refund. And 2. Bring an action in court within 30 days from decision or inaction by the local treasurer, whether such action is denominated as an appeal from assessment and or claim for refund of erroneously or illegally collected tax. Cosmos may resort to, as it actually did, the alternative procedure of seeking a refund after timely protesting and paying the assessment. Considering that Cosmos initiated the judicial claim for refund within 30 days from receipt of the denial of its protest, it stands to reason that the assessment which was validly protested had not yet attained finality. It could then validly institute the refund despite its previous protest and payment of the assessment. Claim for refund or tax credit for erroneously or illegally collected tax, fee, or charge. International Container Terminal Services versus the City of Manila et al. GR 185622, October 17, 2018. Facts: International Container Terminal Services, or ICTSI, was assessed for 2 local business taxes pursuant to an ordinance. ICTSI paid the taxes under protest in order to be issued its business permits. Such protests only covered the assessments for the first 3 quarters of 1999. When the city treasurer failed to act within 60 days from the protest, ICTSI filed a petition for certiorari and prohibition before the regional trial court. However, the RTC dismissed the petition because the proper remedy should have been an appeal within 60 days from the receipt of the denial of the city treasurer to the Court of Tax Appeals as prescribed under Section 195 of the Local Government Code. The RTC held that for ICTSI's failure to avail of the proper remedy, the assessments made against it became conclusive and unappealable. In a petition for review before the CTA Division, the division ordered a partial refund representing the erroneously paid business taxes for the first 3 quarters of 1999. It did not order the City of Manila to refund the taxes paid by ICTSI beginning the 4th quarter of 1999 because ICTSI failed to substantiate its claims under Section 195 of the LGC. ICTSI, however, argued before the CTA and Bank that Section 196 of the LGC should be applied because it was requesting for a refund for the erroneously paid taxes. However, the CDA and Bank decided in favor of City of Manila, finding that since ICTSI paid the taxes under the assessment, its claims for refund assumed that the assessment was wrong. Hence, this petition before the Supreme Court. ICTSI argues that the taxes were required for the issuance of its business permit, hence it was forced to pay the assessment under protest. It states that it was exactly the situation contemplated under Section 196 of the LGC, which involves the recovery of any tax, fee, or charge erroneously or illegally collected, thus reiterating the applicability of Section 196 in the present situation. Issue: which between Section 195 or 196 of the Local Government Code governs ICTSI's claim for refund? Ruling: Section 196 is applicable because there was no notice of assessment issued by the local treasurer after the 3rd quarter of 1999. Section 195 and 196 of the LGC govern the remedies of a taxpayer for the taxes collected by the local government units except for real property taxes. Section 195 of the LGC is a proper remedy against notice of assessment issued by the local treasurer. If the taxpayer receives an assessment and does not pay the tax, its remedy is strictly confined to Section 195. It is the written protest with the local treasurer that constitutes the administrative remedy. On the other hand, if no assessment notice is issued by the local treasurer, and the taxpayer claims that it erroneously paid a tax, fee, or charge, or that the tax, fee, or charge has been illegally collected from him, then Section 196 applies. In Section 196, it is the written claim for refund with the local treasurer that constitutes the administrative remedy. Here, no notice of assessment for deficiency taxes was issued by the city treasurer to ICTSI for the taxes collected after the first 3 quarters of 1999. Thus, Section 195 cannot apply subsequent to these periods. In order to apply Section 195 of the LGC, there is a need for the issuance of a notice of assessment stating the nature of the tax, fee, or charge, the amount of deficiency, the surcharges, interests, and penalties. Yet, the assessments from the 4th quarter of 1999 onwards were merely municipal license receipts, mayor's permit, business taxes, fees and charges receipts, and official receipts issued by the Office of the City Treasurer for local business taxes, which must be paid as prerequisite for the renewal of petitioner's business permit in respondent City of Manila. While these receipts state the amount and nature of the tax assessed, they do not contain any amount of deficiency, surcharges, interests, and penalties due from petitioner. They cannot be considered the notice of assessment required under Section 195 of the Local Government Code. Hence, Section 196 of the LGC applies for claims arising out of the taxes paid beginning the 4th quarter of 1999. Real property taxation, imposition of real property tax. Herarch Realty Corporation versus the Provincial Treasurer of Batangas et al. GR 201736, September 5, 2018. Justice Peralta. Facts: 13 parcels of land in Batangas are registered under the name of Herrick Realty Corporation, or Herrick Realty, an entity whose real properties are subject to real property tax, or RPT. These properties had been in the actual possession of Dr. Rafael Manalo, Grace Oliva, and Frida Yap from March 2006 up to August 12, 2009. By virtue of a writ of execution ordered by the Makati Regional Trial Court, Herrick Realty was only able to take full possession and control of the subject properties on August 13, 2009. The provincial treasurer of Batangas assessed Herrick Realty with unpaid real property taxes over the properties, which included the unpaid RPT for the years 2007, 2008, and 2009 from January to August. Herrick Realty paid the assessment under protest, contending that the RPT assessment is illegal and erroneous because the subject property was not in its possession during the COVID period. It alleged that unpaid taxes chargeable against Manalo, Oliva, and Yap, as they had actual or beneficial use and possession of the properties regardless of whether or not he is the owner thereby at the time of the real property tax accruals. The regional trial court denied the petition, stating that the real estate property must be the one who would be responsible for the payment of RPT if the beneficial user failed to pay the required RPT. Issue: is Herrick Realty liable for the RPT assessed over the subject properties? Ruling: yes. Herrick Realty is liable and shall pay for the real property tax over the subject properties. In real estate taxation, the unpaid taxes attaches to the property. The personal liability for the tax delinquency is generally on whoever is the owner of the real property at the time the tax accrues. This is a necessary consequence that proceeds from the fact of ownership. Therefore, as a rule, an entity not exempt from payment of taxes must be responsible for the payment of the deficiency taxes under the theory that unpaid taxes attached to the land. It follows then that the beneficial user of the property owned by tax-exempt entity must be answerable for the payment of RPT on the real estate property owned by tax-exempt entity. Another case: Metropolitan Waterworks Sewerage System versus Local Government of Quezon City et al. GR 194388, November 7, 2018. Facts: in 1971, Congress enacted Republic Act 6234, creating the Metropolitan Waterworks and Sewerage System, MWSS. Sometime in July 2007, the local government of Quezon City assessed MWSS with real property tax delinquency for various taxable years. MWSS filed for certiorari with TRO with the Court of Appeals. It argued that its real properties were exclusively devoted to public use. MWSS also contends that it is a government instrumentality exempt from said tax under Section 133, letter O of the Local Government Code. It points out that Section 18 of its charter expressly exempts it from the payment of RPT. Further, MWSS argues that it is an instrumentality of the government holding properties of the public dominion, even directing the attention of the court to execute Order Number 596 issued in 2006, which categorizes MWSS as a government agency that is exempt from the payment of real property taxes, and to RA number 10149, where the Congress listed it as one of the government instrumentalities with corporate powers like the Manila International Airport Authority and the Philippine Fisheries Development Authority. On the other hand, Quezon City points out that MWSS holds properties in the exercise of its proprietary functions, and thus are susceptible to real property tax. They point out that the provision granting them exemption has since been repealed by Section 234 of the LGC enacted in 1990. Issue: can the local government of Quezon City assess real property taxes on MWSS, a government entity? Ruling: no. Under the LGC, local government unions are granted the power to levy taxes on real property not otherwise exempted under the law. The same code also provides two specific limitations on the LGU's power to tax. The court also ruled in the case of Manila International Airport Authority versus Court of Appeals that government instrumentalities are exempt from payment of RPT under Section 133, letter O of the LGC. A government-owned and controlled corporation, GOCC, on the other hand, is not exempt from RPT under Section 234 of the same code, which would have the exemption. Applying these parameters, the court concluded that MWSS is a GOCC. Thus, under the LGC, only its machinery and equipment actually, directly and exclusively used for public purposes is exempt from RPT. However, the court's categorization cannot supplant that which was previously made by the executive and legislative branches. Based on the facts, MWSS has already been expressly categorized as a government instrumentality with corporate powers exempt from RPT by EO number 596 and RA number 10149. Therefore, MWSS is not liable to Quezon City for real property taxes, except if the beneficial use of its properties has been extended to a taxable person. Quezon City has not alleged that the beneficial use of any of MWSS properties was extended to a taxable person. In the absence of any allegations to the contrary, MWSS properties in Quezon City are not subject to the levy of real property taxes. Remedies of LGUs for collection of real property taxes, issuance of notice of delinquency for real property tax payment. Noemi Cruz and heirs of Hermenegildo T. Cruz, represented by Noemi Cruz, versus City of Makati et al. GR number 210894, September 12, 2018, Justice Del Castillo. Facts: spouses Noemi and Hermenegildo Cruz, spouses Cruz, were the registered owners of the subject property in Makati City, which was levied upon by the City of Manila for non-payment of real property taxes thereon after their designated employee representative failed to remit the entrusted tax payments to the city and appeared to have absconded with the money instead. Eventually, the subject property was auctioned off and sold to the highest bidder, Laverne Realty and Development Corporation, or Laverne. In 2007, spouses Cruz filed a complaint before Makati Regional Trial Court, alleging that the delinquency sale of their property was null and void because of the following grounds. A. No warrant of levy was ever received by them. B. The notice of delinquency sale was not posted in the City Hall of Makati and in the barangay where the property is located in compliance with Section 254 of the Code. C. The notice of billing statements for real property were mistakenly sent to Unit 1407 instead of Unit 407. And D. The Makati Treasurer's Office did not notify the spouses of the warrant of levy as required by the LGC. Is the levy by the City of Makati of the property and its subsequent sale through auction valid? Ruling: no. Section 254 of the LGC provides for the posting and publication requirement for the notice of delinquency in a tax delinquency sale. Section 258, meanwhile, provides for the rules to be observed in the issuance and service of a warrant of levy upon the taxpayer. And finally, Section 260 provides for the requirements to be followed by the local treasurer in a public auction sale of the levied properties. These requirements are mandatory. Strict adherence is imperative not only for the protection of the taxpayers, but also to dispel any possible suspicion of collusion between the buyer and the public officials. The non-fulfillment of these requirements vitiates the sale. In this case, there was no evidence presented that the notice of tax delinquency was posted in the City Hall of Makati and in the barangay where the property is located in compliance with Section 254 of the Code. Instead, the records showed that the City of Makati merely requested a certification from the barangay indicating that the list of properties for public auction were posted in the said barangay. However, the barangay certification itself was not presented in court. Furthermore, a mere request for certification is not sufficient compliance with the law. The law provides that the notice of tax delinquency must be published twice in the newspaper of general circulation. However, the evidence presented shows that the notice of tax delinquency was published only once on March 25, 2006, while the notice of public auction was published thrice. It must be again remembered that the notice of public auction is different from the notice of tax delinquency. Furthermore, there was no showing that the advertisement for the public sale of the delinquent property, as required by the LGC, was actually served or received by Noemi Cruz. The law requires service of the warrant of levy to the taxpayer. The registry receipt merely proves that the same was mailed, but the actual service of receipt of the same by the delinquent taxpayer cannot be deduced therefrom. Likewise, there is also doubt as to whether the billings were sent to the correct address of the respondents, as the notations in the upper portion of the billings pertain to a Unit 1407 instead of Unit 407. Therefore, having failed to meet the mandatory due process requirements prescribed by the LGC regarding tax delinquency sales, the levy by the City of Makati of the properties of the spouses Cruz shall be rendered null and void. Contesting an assessment of value of real property, appeal to the Local Board of Assessment Appeals. Contesting an assessment of value of real property, appeal to the Local Board of Assessment Appeals. The case is Alliance of Quezon City Homeowners Association Incorporated versus the Quezon City Government, GR 230651, September 18, 2018. Justice Perlas Bernabe. Facts. In 2010, the Department of Interior and Local Government, DILG, and the Department of Finance, DOF, issued a memorandum directing all local government units, LGUs, to implement Section 219 of the Local Government Code, which requires assessors to revise the real property assessments in their jurisdictions. Hence, the preparation of the Quezon City assessor of a revised schedule of the fair market values, which was later on approved by the LGU of Quezon City. Alliance filed a petition directly before the Supreme Court, claiming that the 2016 ordinance is unconstitutional for violating substantive due process, considering that the increase in fair market values, which resulted in an increase in the taxes to be paid, was unjust, excessive, oppressive, arbitrary, and confiscatory as prescribed under Section 130 of the LGC. Quezon City Government countered that Alliance failed to exhaust its administrative remedies, as they should have first filed a protest before the city treasurer, as well as assailed the constitutionality of the 2016 ordinance before the Secretary of Justice. In its reply, Alliance argued that the exhaustion of such remedies is inapplicable in this case because of the strong public interest involved. Is the petition infirm for violating the doctrine of exhaustion of administrative remedies? Ruling is no. The doctrine requires that before a party may seek intervention from the court, he or she should have already exhausted all the remedies in the administrative level. the LGC provides two remedies in relation to real property tax assessments or tax ordinances. First, an appeal to local Board of Assessment Appeals to question the reasonableness of the amount assessed, and second, an appeal before the Secretary of Justice to question the validity or legality of a tax ordinance. However, the rule has exceptions, one of which is when strong public interest is involved. An LGU's authority to increase the fair market values of properties for purposes of local taxation is a question that affects the public at large. In this case, the effect of the 2016 ordinance is apparent, considering that Quezon City has a land area of 16,112.8 hectares, which is almost one-fourth of Metro Manila. Furthermore, Quezon City holds 23.3% of Metro Manila's total population. Accordingly, the court exempts this case from the rule on administrative exhaustion. Judicial Remedies, Court of Tax Appeals, Jurisdiction of the Court of Tax Appeals. Case is Commissioner of Internal Revenue versus Bank of the Philippine Islands, GR 224327, June 11, 2018, Justice Peralta. Facts: City Trust Banking Corporation or CBC filed its annual income tax returns for taxable year 1986. Afterwards, the Commissioner of Internal Revenue issued a pre-assessment notice and demand letters against CBC for deficiency income taxes. In turn, CBC's counsel offered a compromise settlement on its deficiency income tax assessment, which the CIR approved. CBC's request for reconsideration of the amount of the compromise was ultimately denied by the CIR. Pursuant to the said denial, the CIR issued a notice of denial addressed to the Bank of the Philippine Islands, requesting for the payment of CBC's deficiency income tax for taxable year 1986. The CIR also issued a warrant of distraint and/or levy against BPI, prompting the latter to file a petition for review with the Court of Tax Appeals. The CDA Special Third Division held that BPI can validly assail the warrant of distraint and/or levy, as its appellate jurisdiction was not limited to cases which involved decisions of the CIR on matters relating to assessment or refunds. Aggrieved, the CIR filed a petition for review with the CDA and Bank. The CDA and Bank affirmed the ruling of the division, hence this petition. Issue: Does the CDA have jurisdiction over cases asking for cancellation and withdrawal of a warrant of distraint or levy? Ruling: Yes. The CDA has jurisdiction over cases asking for cancellation and withdrawal of a warrant of distraint or levy. Pursuant to Section 7 of Republic Act No. 9282, CDA has exclusive appellate jurisdiction to review by appeal when there is inaction by the CIR in cases involving disputed assessments, refunds of internal revenue taxes, fees or other charges, penalties in relation thereto, or other matters arising under the National Internal Revenue Code or other laws administered by the BIR. The instant case falls under the other matters, cognizable by the CDA in view of its appellate jurisdiction. The CDA did not err in its ruling that it has jurisdiction over cases asking for the cancellation and withdrawal of a warrant of distraint and/or levy. Another case, Basis Conversion and Development Authority versus Commissioner of Internal Revenue. Tier 205925, June 20, 2018, Justice Reyes Jr. Facts: Basis Conversion and Development Authority, BCDA, filed a petition for review with Court of Tax Appeals in order to preserve its rights to pursue its claim for refund of creditable withholding tax, or CWT, in connection with its sale of the BCDA allocated units as its share in the Rendra project pursuant to the joint development agreement with Ayala Land. The petition for review was filed with a request for exemption from payment of filing fees. The CDA First Division denied BCDA's request for exemption. The motion for reconsideration and appeal with the CDA and bank was likewise denied, stating that due to BCDA's non-payment of the prescribed legal fees, the court has not acquired jurisdiction over the case. BCDA emphasized its position that it is exempt from the payment of such fees, hence this petition. Issue: is BCDA exempt from the payment of docket or legal fees to the Court of Tax Appeals? Ruling is yes. BCDA is exempt from the payment of docket or legal fees to the Court of Tax Appeals. In view of Section 3 of Republic Act number 7227, also known as the Basis Conversion and Development Act of 1992, BCDA is a government instrumentality vested with corporate powers. It is an authorized capital of 100 billion, not divided into shares of stock. BCDA has no voting shares and likewise has no provision which authorizes the distribution of dividends and allotments of surplus and profits to BCDA stockholders. Hence, BCDA is not a stock corporation. It also does not qualify as a non-stock corporation because it was organized for the purpose of owning, holding, and or administering the military reservations in the country and implement its conversion to other productive uses. All told, it is clear that BCDA is a government instrumentality which is exempt from the payment of docket fees required under Section 21, Rule 141 of the Rules of Court. Another case, Confederation for Unity, Recognition, and Advancement of Government Employees et al. Versus Commissioner Bureau of Internal Revenue, GRs 213446 and 213658, July 3, 2018, Justice Kagiwa. Facts: Commissioner of Internal Revenue issued the Assailed Revenue Memorandum Order 23, 2014. Confederation for Unity, Recognition, and Advancement of Government Employees, or COURAGE et al., immediately filed a petition for prohibition and mandamus imputing grave abuse of discretion on the part of the CIR before the Supreme Court. Issue: is there a violation of the doctrine of exhaustion of administrative remedies? B. Is there a violation of the rule on hierarchy of courts? The ruling is yes, there is a violation of the doctrine of exhaustion of administrative remedies. The plain, speedy, and adequate remedy expressly provided by law is an appeal of the assailed RMO with the Secretary of Finance under Section 4 of the National Internal Revenue Code, which provides that the power to interpret the provisions of this code and other tax laws shall be under the exclusive and original jurisdiction of the CIR, subject to review by the Secretary of Finance. Clearly, the assailed RMO falls under the revenue issuances that are subject to the review of the Secretary of Finance. Therefore, a taxpayer who is aggrieved by the CIR's ruling is granted a period of 30 days from receipt of the adverse ruling by the CIR to file with the Office of the Secretary of Finance a request for review in writing and under oath. In this case, since Courage et al. Failed to file an administrative appeal to the Secretary of Finance and to prove the existence of any of the recognized exceptions to the salutary rule of the doctrine of exhaustion of administrative remedy, there exists a ground to dismiss the petition. Letter B. Yes, there is a violation of the rule on hierarchy of courts. Rulings of the Secretary of Finance in the exercise of its power to review under Section 4 of the NIRC of 1997, as amended, are appealed to the Court of Tax Appeals. The Court explained that while there is no law which explicitly provides where rulings of the Secretary of Finance under the adverted to NIRC provision are appealable, Section 7, letter A of RA 1125, the law creating the CDA, is nonetheless sufficient, albeit impliedly, to include appeals from the Secretary's review under Section 4 of the NIRC. That is, the CDA has exclusive appellate jurisdiction to review on certiorari the constitutionality or validity of revenue issuances, even without a prior issuance of an assessment. Here, Courage et al. violated the rule on hierarchy of courts as the petition should have been initially filed with the CDA, having the exclusive appellate jurisdiction to determine the constitutionality or validity of revenue issuances. Nevertheless, despite the procedural infirmities of the petitions that warrant their outright dismissal, the Supreme Court deemed it prudent, if not crucial, to take cognizance of and accordingly act on the petitions as they assail the validity of the actions of the CIR that affect thousands of employees in the different government agencies and instrumentalities. Another case, Macario Lim Gao Jr., Commission of Internal Revenue, GR 222837, July 23, 2018. Judge or Justice Tiam. Facts: Macario Lim Gao Jr., or Gao for short, was confused as to whether he had to pay docket fee on the belief that the civil action for recovery of civil liability for taxes and penalties of 2008 was deemed instituted in the criminal case of tax evasion. Gao filed a motion in order to clarify whether he has to file a separate petition to question the deficiency assessment. CTA Division held that the recovery of the civil liability is deemed instituted with a criminal case. As a caution, petitioners still filed a petition for review ad cautelam with motion for consolidation with CTA criminal case. Upon filing of the said petition, the clerk of court of the CDA assessed Gao with zero filing fees. CDA Division dismissed the case on the ground that Gao did not pay the filing fee. The CDA and bank affirmed the said decision of the CDA Division. Issue: did the CDA and bank err in affirming the dismissal of the case? Ruling: yes. CDA and bank erred in affirming the dismissal of the case. Basic is the rule that the payment of docket and other legal fee is both mandatory and jurisdictional. The court acquires jurisdiction over the case only upon the payment of the prescribed fees. In this case, records reveal that Gao has no intention to defraud the government in not paying the docket fees. In fact, when he appealed the FDAA insofar as the taxable year 2007 was concerned, he promptly paid the docket fees when he filed his petition for review. Confusion resulted when the FDAA also covered tax deficiencies pertaining to taxable year 2008, which was also the subject of the consolidated criminal case for tax evasion. The CDA Division even stated that the civil action was already deemed instituted with the criminal case. Gao merely relied in good faith that he is no longer required to pay the docket fees. As such, CDA erred in simply dismissing the case on the ground of non-payment of docket fees. Another case, Nippon Express Philippines Corporation with Commissioner of Internal Revenue, GR 191495, July 23, 2018, Justice Martires. Facts: on 30th March 2005, Nippon Express filed with the Bureau of Internal Revenue an application for tax credit of its excess or unused input taxes attributable to zero-rated sales. By reason of the inaction of the BIR, Nippon Express filed a petition for review before the Court of Tax Appeals on March 31, 2006. The CDA Division ruled in favor of the CIR. Nippon Express filed a motion for reconsideration but was denied by the CDA in its resolution. Hence, Nippon Express filed a petition for review with the CDA and bank. The CDA and bank affirmed the decision of the CDA Division. Issue: did the CDA validly obtain jurisdiction over the case? Ruling is no. The CDA did not validly obtain jurisdiction over the case. Section 112 of the National Internal Revenue Code states that a VAT-registered taxpayer may file its claim for refund with the BIR within 2 years from the close of the taxable quarter when the pertinent zero-rated sales were made. The CIR is given a 120-day period to decide. In case of whole or partial denial of an inaction on the administrative claim, the taxpayer may appeal to the CDA within 30 days counted from the receipt of the decision or inaction by the CIR. This 30-day period of appeal is mandatory and jurisdictional. In this case, Nippon Express timely filed its administrative claim on 30th March 2005 or within the 2-year prescriptive period. The CIR had 120 days or until 28 July 2005, the last day of the 120-day period to decide the claim. The CIR did not act on it, thus Nippon Express had until August 27, 2005, the last day of the 30-day period, within which to appeal to the CDA. However, Nippon Express filed its petition for review with the CDA only on March 31st, 2006, or 246 days from the inaction of the CIR. In other words, the petition of Nippon Express was belatedly filed with the CDA, and the court ought to have dismissed it for lack of jurisdiction. Another case is Herarch Realty Corporation versus the Provincial Treasurer of Batangas et al. GR 201736, September 5, 2018, Justice Peralta. Facts: the Provincial Treasurer of Batangas assessed Herarch Realty with unpaid real property tax over its Batangas properties covering the periods 2007, 2008, and January to August of 2009. The demand was reiterated in letters later on. Herarch Realty paid the assessment under protest, contending that Manalo, Oliva, and Yap should be the ones charged with RPT as they had its actual or beneficial use and possession of the properties at the time the real property tax accrued. Less than a month later, Herarch Realty also filed a petition for prohibition and mandamus before the Regional Trial Court against the Provincial Treasurer of Batangas, which was denied. When Herarch Realty's motion for reconsideration before the RTC was likewise denied, Herarch Realty directly filed before the Supreme Court a Rule 45 petition. Issue: was the direct recourse of Herarch Realty to the Supreme Court proper? Ruling is no. The right to appeal is a statutory right. Thus, the party who intends to appeal must comply with the procedures and rules governing appeals. Otherwise, the right of appeal may be lost or squandered. Under Republic Act 9282, the appellate jurisdiction of the CDA over decisions, orders, or resolutions of the RTC becomes operative when the latter has ruled on a local tax case. Among the possible issues are the legality or validity of the RPT assessment, protest of assessment, disputed assessment, surcharges or penalties, legality or validity of a tax ordinance, claims for tax refund or credit, claims for tax exemption, actions to collect taxes due, and even prescription of assessment. Evidently, Herarch Realty erred in its appeal. Herarch Realty's direct recourse to the RTC is warranted, since the issue of the legality or validity of the assessment is a question of law. However, as a taxpayer not satisfied with the RTC decision, it should have filed a petition for review before the Court of Tax Appeals. The decision, ruling, or resolution of the CDA sitting as division may further be reviewed by the CDA en banc. It is only after this procedure has been exhausted that the case may be elevated to the Supreme Court. Another case, Commissioner of Internal Revenue versus Standard Insurance Company, GR 219340, November 7, 2018, Judge or Justice Bersamin. Facts: Standard Insurance Company, or Standard Insurance for short, received from the Bureau of Internal Revenue a preliminary assessment notice, PAN, for deficiency in payment of documentary stamp tax for taxable year 2011. Standard Insurance contested the PAN, but the BAR sent a formal letter of demand. Later, Standard Insurance received the final decision on disputed assessment, FDAA. It sought reconsideration of the FDAA and objected to the tax imposed pursuant to Section 184 of the National Internal Revenue Code as violative of the constitutional limitation on taxation. Instead of filing an appeal before the Court of Tax Appeals, Standard Insurance filed a civil case before the RTC for declaratory relief with a prayer of TRO and or a writ of preliminary injunction. The RTC issued a TRO and eventually issued a writ of preliminary injunction enjoining the BAR to implement the provision of the NIRC and collect the assessed taxes from Standard Insurance. The Commissioner of Internal Revenue appealed directly to the Supreme Court. Issue: is declaratory relief procedurally proper as a remedy? Ruling: no. Standard insurance proper remedy upon receipt of the FDDA for the DST deficiency for taxable year 2011 was not the action for declaratory relief but an appeal taken in due course to the CDA. In this case, instead of appealing in due course to the CDA, it resorted to the RTC to seek and obtain declaratory relief. By choosing the wrong remedy, Standard Insurance lost its proper and true recourse. Worse, the choice of the wrong remedy rendered the assessment for the DST deficiency for taxable year 2011 final as a consequence. As such, the petition for declaratory relief, assuming its propriety as a remedy for standard insurance, became mooted by the finality of the assessment. Another case, City of Manila versus Cosmos Bottling Corporation. Justice Martirez. Facts: the City of Manila, through its treasurer, assessed Cosmos Bottling Corporation, Cosmos local business taxes. Cosmos protested the assessment. The city treasurer denied the protest. Nevertheless, Cosmos paid the amount as assessed, and later Cosmos filed a claim for refund. Due to the inaction of the city treasurer of Manila in the claim for refund, Cosmos filed a complaint with the regional trial court. That regional trial court ruled for Cosmos but denied the claim for refund. Cosmos then filed a petition for review before the Court of Tax Appeals. The CDA division affirmed the finding of the RTC and ordered a refund of the amount paid. Aggrieved, the City of Manila filed a petition for review directly with the CDA and bank. The CDA and bank ruled that direct resort to it without prior motion for reconsideration or new trial before the CDA division violates rules of procedure. Issue: is the filing of a motion for reconsideration or new trial before the CDA division an indispensable requirement for filing an appeal before the CDA and bank? Ruling: yes. The filing of a motion for reconsideration or new trial before the CDA division is an indispensable requirement for filing an appeal before the CDA and bank. Failure to file such motion for reconsideration or new trial is cause for dismissal of the appeal before the CDA and bank. Section 1, Rule 8 of the CDA Rules provides Section 1, Review of cases in the court and bank. In cases falling under the exclusive appellate jurisdiction of the court and bank, the petition for review of a decision or resolution of the court in division must be preceded by the filing of a timely motion for reconsideration or new trial with the division. It is clear from the cited rule that the filing of a motion for reconsideration or new trial is mandatory, not merely directory, as indicated by the word must. Thus, CDA and bank did not acquire jurisdiction over the petition of the City of Manila. Procedures: non-availability of injunction to restrain collection of tax. Commissioner of Internal Revenue versus Standard Insurance Company. GR 219340, November 7, 2018. Justice Bersamin. Facts: Standard Insurance Company, Standard Insurance, received from Bureau of Internal Revenue assessment notices regarding its liability arising from a deficiency taxes for taxable year 2011 and subsequently received a final decision on disputed assessment FDDA. Standard Insurance objected to the tax imposed pursuant to Section 184 of the National Internal Revenue Code as violative of the constitutional limitations on taxation. Later, Standard Insurance received a demand for payment for its deficiency income taxes, VAT, and other taxes for taxable year 2012 and deficiency documentary stamp tax for 2013. Standard Insurance filed a civil case before the Regional Trial Court with a prayer for issuance of temporary restraining order or a writ of preliminary injunction for judicial determination of constitutionality of Sections 108 and 184 of the NIRC with respect to the tax to be paid by non-life insurance companies. The RTC issued the TRO with respect to the FDDA and to the pending assessments for taxable years 2012 and 2013. Later, the RTC issued a writ of preliminary injunction. The Commissioner of Internal Revenue moved for reconsideration but was denied. The CIR appealed directly to the Supreme Court. Ruling: is the injunctive relief available as a remedy to assail the collection of taxes? Ruling is no. Section 21(8) of the NIRC expressly provides that no court shall have the authority to grant an injunction to restrain the collection of any national internal revenue tax, fee, or charge imposed by the NIRC. Thus, the RTC not only grossly erred in giving due course to the petition for declaratory relief and in untimely deciding to permanently enjoin the enforcement of the specified provisions of the NIRC against standard insurance. Even worse, RTC acted without jurisdiction. Institution of civil action and criminal action. The case of Macario Lim Gao versus Commission of Internal Revenue. GR 222837, July 23, 2008. Facts: Macario Lim Gao conveyed 10 parcels of land to Eagle Gao and paid the assessed capital gains tax or CGT and documentary stamp tax DST arising from the sale of the parcels of land. After payment, the Revenue District Officer RDO issued the corresponding certificates authorizing registration and tax clearance certificates. 2 years later, the Commissioner on Internal Revenue opined that Gao was not liable for the CGT but for the 32% regular income tax and 12% value-added tax because the properties sold were ordinary assets. 2 criminal information for tax evasion was filed against Gao. Halfway through the trial, CIR issued a final decision in disputed assessment FDDA against Gao, assessing him of deficiency taxes for the years 2007 and 2008. With respect to the deficiency assessment for 2008, which is already covered by the criminal case, Gao filed a petition for review ad cautelam with the Court of Tax Appeals. The CDA dismissed the petition for review ad cautelam due to Gao's non-payment of filing fee. Gao argued that the civil aspect of the criminal case, which is the petition for review ad cautelam, is deemed instituted upon the filing of the criminal action. Thus, the CDA had long acquired jurisdiction over the civil aspect of the consolidated criminal cases. Therefore, the CDA erred in dismissing the case. Issue: is the civil action questioning the FDDA deemed instituted with the criminal case for tax evasion? Ruling: no. The civil action questioning the FDDA is not deemed instituted with the criminal case for tax evasion. It is well settled that the taxpayer's obligation to pay the tax is an obligation that is created by law and does not arise from the offense of tax evasion. As such, the same is not deemed instituted in the criminal case. Here, contrary to Gao's contention, the civil aspect is not deemed included in the tax evasion case. The CDA had not acquired jurisdiction over the civil case. Whew, and that's the end of it. On my next upload, I will be reading random cases decided by the Supreme Court in the year 2020. So if you're not yet subscribed, go ahead and hit the subscribe button and we study together. Thanks.